The purpose of this presentation is to advise independent contractors licensed with Realty Executives Arizona territory of the pitfalls and liability exposure under the Telephone Consumer Protection Act and the Telephone Sales Rule. Real estate professionals across America have been utilizing customer relationship management and sales acceleration technologies to increase sales for years. One of the most well-known features of sales acceleration technologies are auto dialers or predictive dialers. More than 30 years ago, a United States Senator pontificated that computerized calls are the scourge of modern civilization. He said, quote, "They wake us up in the morning, they interrupt our dinner at night, they force the sick and elderly out of bed. They hound us until we want to rip the telephone right out of the wall." Obviously a reference to 1990s telephone technology. So you have the convenience and efficiency of telemarketing and technology colliding with the negative opinion of and law surrounding these practices in what is known as the Telephone Consumer Protection Act, which was passed in 1991, and the Federal Trade Commission's Telephone Sales Rule. In 2018, an estimated 47 billion robocalls were made to landlines and cell phones in the United States. On average, the Federal Trade Commission, or FTC, receives 250,000 complaints regarding the TCPA per month. The number of consumer complaints to the FTC about unwanted telemarketing calls was 5.4 million in fiscal year 2019. As of 2019, there were more than 239 million phone numbers registered on the Do Not Call registry. The TCPA and TSR have spawned a cottage industry of professional plaintiffs and class action plaintiffs lawyers that are systematically targeting businesses. TCPA litigation is now primarily conducted via class actions in federal court with crippling potential damages. The real estate industry has become an increasing target of new lawsuits and class action lawsuits under the TCPA and TSR. Class action lawsuits asserting claims under the TCPA were filed against Presidential Real Estate Group, Inc., doing business as Remax Presidential, and Keller Williams Realty in late 2019, and My Home Group Real Estate out of Arizona in the spring of 2020. The real estate sector is just the latest part of our economy to be hit by a rash of these TCPA class action lawsuits, which has the potential for significant liability exposure. Businesses in other industries have been hit with TCPA lawsuits and often end up settling such claims for amounts in excess of $50 million. Between 2014 and 2017, there were at least 18 TCPA settlements over $14 million. The most famous TCPA settlement occurred in August of 2014 when Capital One and 3 collection agencies agreed to pay $75.5 million to end a class action lawsuit that arose from the bank's use of an auto dialer to call consumer cell phones. Caribbean Cruise Line agreed to pay up to $76 million in September of 2016, and Dish Network settled a case for $61 million in October of 2017. Even if a lawsuit is not brought as a class action, the liability could be high for real estate professionals. The TCPA provides a private right of action to any person or entity for TCPA violations and the possibility of collecting for the actual monetary loss or $500, whichever is greater, for each violation. A called party may receive up to 3 times that amount if the caller willfully and knowingly violated the TCPA. In other words, an agent may be exposed to liability of between $500 and $1,500 for each call, text, or facsimile. However, if actual damages exceed $500 per incident, the damages could be greater. As an example, let's say an agent called an expired listing using an auto dialer system and left a pre-recorded message to a phone number listed on the Do Not Call list. If it was not a willful violation, the court would likely award $1,500 for the 3 violations. If it was determined that the agent knew or should have known they were calling a person who did not provide prior express consent, the calls could be seen as deliberate violations, increasing the award to $4,500. The TCPA leaves it up to the court to decide what is a knowing or willful violation. Another very serious consideration, if an agent is sued, is the formal discovery and disclosure process in lawsuits. This is the formal process of exchanging information between the parties about the witnesses and evidence they'll present at trial. Discovery enables the parties to know before the trial begins what evidence may be presented. One of the most common methods of discovery is to take depositions. Other methods of discovery include subpoenaing or requiring the other side to produce books, records, or other documents for inspection. These could include phone records, client lists, emails, and text history, and evidence of your own internal do not call list, or lack thereof, as the case may be. This is scary. If an attorney in a case finds out that you have violated the TCPA in the past, it is possible that that attorney could go fishing to recruit a class for a class action. 9 out of 10 cases filed in the courts of the United States settle before trial, but few of those cases settle prior to the completion of discovery. Let's look at some real-world cases. One of the biggest cases involving real estate agents is Hayhurst versus Keller Williams, filed in the fall of 2019. In the Keller Williams case, the plaintiff, Hayhurst, had his property listed for sale with another company in a private broker database, probably something like MLS. The listing expired before a sale could be made. After it expired, Hayhurst immediately started getting robocalls from Keller Williams Realty, trying to convince him to relist his property through their agency. Hayhurst, whose number has been on the National Do Not Call Registry for over 15 years, didn't appreciate the solicitations and hired an attorney specializing in class action lawsuits about privacy rights, unfair business practices, and the Telephone Consumer Protection Act. Never underestimate the power of anger and the appeal of a large settlement. In his complaint, Hayhurst alleged that Keller Williams' marketing plan resulted in at least 3 unsolicited, auto-dialed, and pre-recorded calls to his personal cell phone that is registered on the DNC. Hayhurst did not give any express prior consent to receive these calls from Keller Williams. Central to Hayhurst's case was the Keller Williams agent's use of a product called LandVoice. LandVoice promotes itself as a marketing tool that dials leads for the agent, that allows an agent to dial up to 80 calls per hour, offers a 4-line dialer that can call 300 leads an hour, leaves pre-recorded messages with a simple click. In my opinion, it literally advertises itself as a major violator of the TCPA. There are no guarantees, and I would go so far as to say you will not be able to hold a third-party vendor responsible for selling you a system that violates the TCPA. In Remax Presidential, the plaintiff, Williams, sued Remax Presidential in federal court on August 1, 2019, for using an auto-dialer to send text messages. Williams alleged that the realty company sent her telemarketing text messages without her consent. The first message read, "Save, save, save now. Many of our listings we get direct buyers. Sellers then will only pay 3%. A second message asked, "If you are thinking of selling, we may save you 3% commission. We helped many sellers." And a third message inquired, "Is your home still for sale? I have 3 qualified buyers for the area. Please let me know. Thanks." A day earlier, Williams' lawyer filed a similar federal lawsuit against another brokerage with 4 offices in South Florida. Florida was a hotspot in the fall of 2019, as 2 other TCPA lawsuits were filed against brokerages, including a Coldwell Banker brokerage. At least 3 of those cases settled, as the attorneys involved filed more lawsuits against more brokerages. In Drake v. First Key Homes, a real estate team whose business included property management called a phone number in response to a residence viewing request that someone had placed through Zillow. The real estate team placed 2 calls to the number. The first call was placed by an agent who left a personal message identifying herself, who her company was, indicated she was aware that the person she thought she was calling had toured 2 properties, provided a toll-free callback number, and requested a return call. The second call was a pre-recorded voicemail that identified the team, offered a $500 discount on first month's rent at their properties, and left a callback number. Because a natural person made the first call and manually dialed the number, there were no issues. The call was not considered a violation of the TCPA. But the second call formed the basis of a lawsuit against the real estate team. The claim was that the pre-recorded voicemail violated the TCPA because it used an automatic telephone dialing system to call a cell phone without her consent and left an artificial or pre-recorded voicemail also without her consent. The call also failed to provide an automated opt-out mechanism or a toll-free number to reach an automated opt-out mechanism. The real estate team argued that the person who placed the request through Zillow may have been a former subscriber of the telephone number. The plaintiff in the case admitted as much because she said she'd received calls from several different entities looking for the previous subscriber. Even though the real estate team believed it was calling a number from someone who wanted a return call about their properties, they were kept in the case as a defendant. The matter was litigated for a year and a half and settled on November 10th, 2020. The terms of the settlement are unavailable. Now for maybe the most concerning case. In Marks v. Crunch, which is the law that covers the state of Arizona, a company sent 3 text messages to a customer over a period of 3 months using a web-based marketing platform called Textmunication, designed to send promotional text messages to a list of stored telephone numbers. They used the system to offer incentives to customers, provide appointment reminders and updates, and birthday greetings. The customer in this case, Marks, filed a class action lawsuit against the company. The Ninth Circuit Court of Appeals defined an automatic telephone dialing system as any equipment which has the capacity to 1. Store numbers to be called, or 2. To produce numbers to be called using a random or sequential number generator, and to dial such numbers automatically, even if the system must be turned on or triggered by a person. This definition includes a device that stores telephone numbers to be called, whether or not those numbers have been generated by a random or sequential number generator. There is concern in the legal field that this definition sweeps smartphones into the definition of an autodialer system because it includes all equipment that engages in automatic dialing, not just equipment that operates without any human oversight or control. The parties litigated the matter for nearly 5 years. The company lost in the trial court and was expected to appeal the decision to the United States Supreme Court, but ultimately settled the case. The danger of a TCPA lawsuit against a real estate agent is real. Agents who knowingly use technology to telemarket in violation of the TCPA are putting themselves at risk of potential huge awards or settlements against them. The TCPA has for years created uncertainty and compliance burdens for businesses who telemarket. Supreme Court Justice John Roberts even called it one of the strangest laws he has ever seen. It is proven to be open to multiple interpretations in the courts across the country. The Federal Communications Commission has issued orders trying to clarify provisions in the TCPA, but they have failed woefully. Courts have split as to whether the FCC's prior 2003, 2008, and 2012 orders are still valid. It remains to be seen if we will have any clarity anytime soon. So the best we can do is try to understand the TCPA as it exists today. The Federal Telephone Consumer Protection Act is the law that prohibits telemarketers, banks, debt collectors, and other companies from using an autodialer or robocalls to call a person either at home or on their cell phone without their consent. It provides a private right of action for individuals and the possibility for class action lawsuits. Telemarketing is defined as contacting, qualifying, and canvassing prospective customers using telecommunications devices such as telephone, fax, and internet. If a real estate agent is picking up the phone to call potential clients and solicit new business, they are telemarketing. The TCPA regulates telemarketing calls, auto-dialed calls, pre-recorded calls, text messages, and unsolicited faxes. It is also the authority that created the National Do Not Call list. Telemarketing is an act that functions as an advertisement. The Federal Trade Commission's telemarketing sales rule also governs telemarketing calls and is enforced by the Federal Communications Commission, the Federal Trade Commission, and the Department of Justice. The telemarketing sales rule requires telemarketers to make specific disclosures of material information, prohibits misrepresentations, sets limits on the times telemarketers may call consumers, prohibits calls to a consumer who is asked not to be called again, and sets payment restrictions for the sale of certain goods and services. The TCPA regulates calls and texts to a cell phone using an automatic telephone dialing system. Our advice is to not use them. The exposure to liability and the court's confusion surrounding what is or is not an autodialer is not worth the risk. An autodialer, or ATDS, is defined as equipment which has the capacity to store or produce telephone numbers to be called using a random or sequential number generator, and to dial such numbers. As stated earlier, different courts have interpreted this definition differently, even going so far as to analyze the placement of commas in the definition. A predictive dialer is an outbound calling system that automatically dials from a list of telephone numbers, much like autodialers or robodialers. A predictive dialer automatically calls numbers until it detects a connection, then passes the call to a live agent. These dialers screen out busy signals, voicemails, no answers, disconnected numbers, and so on. It also has the ability to detect if the live agent is available. If the agent is unavailable, it often drops the call. This can get you in real trouble. Under the TSR, it is illegal for telemarketers to abandon any outbound call, with an abandoned call being defined as a call that does not connect the consumer to a sales representative within 2 seconds of the consumer answering the phone. While there is a safe harbor known as the 3% call abandonment rule, that will only be a defense after you've been sued. Again, the advice currently is to not use autodialers or predictive calling systems. Use of an autodialer can rapidly accelerate potential legal damages. If you are already using an autodialer system or decide to use one against this advice, consult with Mark Shin before launching any telemarketing campaign to ensure compliance. The TCPA also prohibits use of artificial or pre-recorded voices to contact cell phones without prior express consent of the called party. An artificial voice is a computer-generated voice. A pre-recorded voice is simply a pre-recorded message that an individual would hear when answering a call. Again, our advice is to never use an artificial voice or pre-recorded message. If you do, you must get the consumer's prior express written consent or you violate the TCPA, and recipients of calls that violate the TCPA may recover up to $1,500 for each violation. The TCPA includes fax rules that prohibit sending unsolicited advertisements by fax, also known as junk faxes, to both businesses and residents, with certain exceptions. A, where the sender has an established business relationship with the recipient, or B, where the fax recipient has given express prior consent to receive a fax. I'm not sure many are still using what is now an outdated form of communication, but if you are, and you are using the fax machine to solicit, you better have consent from the recipient in writing. So we've mentioned consent a lot in this presentation. In certain cases, you must have prior express consent before making a call. In other cases, prior express written consent is required. Prior express written consent is required for calls or texts to cell phones that introduce an advertisement or constitute telemarketing and are sent using an autodialer system. Telemarketing or advertising calls made using an auto dialer system or pre-recorded voice to cell phones or by pre-recorded voice to residential lines require prior express written consent. Non-telemarketing calls and texts to cell phones made using an auto dialer system or pre-recorded voice require prior express consent. Persons who knowingly release their phone numbers to a caller have in effect given their invitation or permission to be called at the number which they have given, absent instructions to the contrary. However, if a caller's number is captured by a caller ID or an ANI device without notice to the residential telephone subscriber, the caller cannot be considered to have given an invitation or permission to receive auto dialer or pre-recorded voice message calls. Because there are areas of law that allow prior express consent, while others require prior written consent, and due to the confusion and uncertainty around the TCPA, it's highly advisable that you get prior written consent that clearly states the customer is consenting to receive calls and texts to their cell phone or pre-recorded voice messages. Under TCPA regulations, prior express written consent requires a written agreement signed by the consumer that includes, among other things, the telephone number that specifically authorizes telemarketing by automatic dialing or texting or pre-recorded voice. Consent cannot be required as a condition of purchase or of engagement for services. It is recommended that your written consent should include language that confirms that the number belongs to the person giving the consent and to no one else. If it is a shared number, you may want to get the additional consent of that person as well. Your written consent should include consent to be called by anyone from Realty executives or their affiliates. Someone handling the paperwork on your transaction or a team member may call or text the buyer or seller, and consent for them to be called should be obtained as well. While this may not be completely necessary, if you're obtaining consent in the first place, you might as well be thorough. Your prior written consent should state that by providing the cell phone number, the consumer agrees that they can be called using an auto dialer system or that you can leave pre-recorded messages or send text messages. It is always advisable to get written or email confirmation, even if verbal consent has been provided. I suggest emailing the person and asking them to confirm that they have given consent. An alternative is to simply state that you are confirming their consent unless they respond to the correspondence that they have not consented. Again, if against the advice contained in this presentation, you choose to use an auto dialer or pre-recorded messages or send text messages for any purpose, you must get written consent to do so, and you must do so prior to sending any messages. As an additional note, it is very unlikely you'll be able to deflect any liability to a third-party vendor who supplies you with lists or the technology described throughout this presentation. If you are using third-party vendors for marketing, get their written confirmation that they have obtained consent from the parties you wish to contact. Now let's talk about the Do Not Call list. The National Do Not Call Registry is a list of phone numbers from consumers who have indicated their preference to limit the telemarketing calls they receive. Anyone on the Do Not Call list is off limits for any type of telemarketing call. Forget about auto dialers and pre-recorded messages. Simply manually dialing someone to offer your real estate services without a pre-existing business relationship is a violation if the person is on the Do Not Call list. If you call someone on the DNC to solicit business from them, you have committed a violation of the telephone sales rule. The Do Not Call provisions of the telephone sales rule covers any plan, program, or campaign to sell goods or services through phone calls. This includes calls by telemarketers who solicit consumers, often on behalf of third-party sellers. It also includes sellers who provide, offer to provide, or arrange to provide goods or services to consumers in return for some type of payment as part of a telemarketing transaction. A violation of the Do Not Call provision of the telemarketing sales rule can be up to $43,280 per call. It is also against Arizona law to initiate an outbound telephone solicitation call to any telephone number if the telephone number is entered into the National Do Not Call Registry. So the takeaway is obviously never call a number on the Do Not Call Registry and honor an individual's request to be added to an internal DNC list. So how do you continue to get business knowing that you might call someone on the DNC? First, check the Do Not Call Registry for the number you are trying to call. The DNC registry is available for someone telemarketing by going to telemarketing.donotcall.gov. Realty Executives Arizona Territory has also added a link to the National Do Not Call list on Prime Agent under Information and Documents. You will need to create a profile, get an organization ID and password, and subscribe to the area codes you want. The first 5 area codes in the subscription are free. After that, you have to pay for additional area codes. You then have to wait for your subscription to be activated. The website says if this is the first time you've subscribed to area codes and you have subscribed to 5 or fewer area codes, it may take up to 1 business day to process the subscription. You may then download phone numbers from your area code subscription lists or use the interactive phone number search module within the website to look up phone numbers. You also need to check Realty Executives' internal Do Not Call list. If someone has advised anyone else in the organization that they do not want to be solicited by someone from Realty Executives, you must honor their request. The alternative is that you may run across a potential plaintiff looking for a payout. The internal Do Not Call list for Realty Executives Arizona Territory is located on the main dashboard of Prime Agent on the left-hand side. If you call someone and they tell you they don't want to be called, you also need to add them to this internal list. It is highly recommended that agents and teams create and keep their own internal Do Not Call list. There is a safe harbor rule if you have complied with certain requirements. As a legal defense, this safe harbor helps to protect companies and agents from inadvertent mistakes that violate DNC rules. It provides a defense against consumer allegations by allowing the calling party to offer proof that they had followed the best practices as defined under the TSR. Those requirements include having written procedures to comply with national DNC rules, including but not limited to how to handle and process DNC requests from consumers, maintaining your own DNC list, using the federal DNC list, and making sure any employee or team member has the training to comply with these rules. Some of you may be wondering about calling for sale by owners. It would seem that they have consented to receiving calls even though they're on the list. For the answer, I'll let Scott Drucker, the General Counsel for and CEO of the Arizona Association of Realtors, answer.
While it's clear that the Do Not Call list generally prohibits telemarketers from calling registered phone numbers when certain criteria are met, it's not quite as clear whether realtors have the right to call a for sale by owner whose number is on the registry. So can you make that call? In typical lawyer fashion, the answer is that it depends. If you're representing a buyer interested in purchasing the property, you can call the for sale by owner even if they are on the Do Not Call registry. The reason being, you are not calling for the purpose of soliciting business from the seller. But what if you're calling the for sale by owner to try and convince them to list the property with you? In other words, hire you as their listing agent. Is that okay? Well, a call of this nature is placed in an attempt by the realtor to market their services. So unless an exception exists, like an established business relationship between the agent and the property owner, the law prohibits the realtor from initiating a call of this nature. And the same is true for calls a realtor may place to an expired listing. So, bottom line, you can call sale by owner who's on the Do Not Call registry if representing a potential buyer, or maybe you're the one trying to purchase the property. But if you're calling to solicit the seller's business, that would constitute a violation of the act.
There are a few other items you should be aware of because they are required under the TSR. Never call a potential client, or I would advise even a current client, before 8 a.m. or after 9 p.m., unless you have express consent. And again, the best practice is to have it in writing. When soliciting anyone, you must include your full name, company name, and contact information clearly and conspicuously in any message you leave. If you leave a pre-recorded message or send a text message, remember you must include opt-out options. Here are some links to some very beneficial resources from the National Association of Realtors and the Arizona Association of Realtors. Additionally, there are a number of other resources on the internet as issues with the TCPA and TSR are occurring across the nation. I recommend that you not rely on any information you obtain from the internet if you are considering a telemarketing program that might present TCPA or TSR issues. Consult an attorney before implementing any campaign, and definitely consult an attorney if you are accused of a violation.